Ladies and gentlemen, I fell off on the job and I didn't intro the show, but it all starts right now.
Your Honor, it would appear that in this matter, a subpoena was issued for Officer Sarchett in the Brandon Branscombe matter. I'm not sure if the court wishes to take that one up at this time or not.
Yes, yes, we should do that. I'm sorry, officer, to make you wait that long. Everybody's backed up here today trying to get it on the docket. Okay, so this is for Samantha Slater.
Your Honor, the state understands that Ms. Slater is also a subpoenaed witness in this case.
For Branscombe. Okay. We are on the record in 2025 CR 185, State of Kansas versus Brandon Lee Branscombe. Jared Regier for the state, Darren Patterson for the defendant. Please start your audio and video, and please find a spot to sit and not be moving around, sir. Can you hear us, Mr. Branscombe?
Yes, Your Honor.
All right, this is a motion to revoke or modify bond. The defendant is alleged to have had contact with a Danielle Erskine pursuant to Newton PD number 25-1121. And that would be in violation of the defendant's bond. I see we do have subpoenaed witnesses Samantha Slater and Officer Brett Sarchett of Newton Police Department. And I understand that Sarah Recheck, agent of Owens Bail Bonding Company, as well as the defendant and his attorney, were notified of the motion to revoke or modify. Mr. Florio is here for Simpson. Do we have anyone here from Owens for Branscombe? All right, Mr. Regier, do you wish to proceed on the motion?
The state is prepared to proceed, Your Honor. However, this does appear to be a case where the information was originally filed by my colleague, Ms. Norris. I understand there may be certain plea negotiations in this matter, so the state would respectfully inquire of counsel for the defense whether what the status of those are.
I'll accept.
And Judge, I would tell the court that I have discussed with Ms. Norris a way to resolve the case without taking up the motion. Based upon that, I believe my client is going to enter a plea of no contest.
Yes.
So you reached an agreement with the state to set aside the motion, but no one canceled the subpoenas. I suppose that's not all bad in case this no contest plea doesn't work out, but it would have been nice to let the officers know. Okay, so before I let you go, since you've waited this long, folks, if you don't mind just bearing with us a little longer. Mr. Branscombe, I'm told you're going to plead no contest to domestic battery, knowing or recklessly causing bodily harm to a family member or person in a dating relationship in Butler County, Kansas on April 16th of 2025. Do you plead no contest to that, or how do you wish to plead?
That's if I understand correctly, that's the domestic battery, a misdemeanor.
That is a misdemeanor class B, alleging that on or about the 16th day of April 2025 in Butler County, Kansas, Brandon Lee Branscombe did knowingly or recklessly cause bodily harm to another person, to wit, Danielle Marie Erskine, a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, as defined by subsection E in violation of KSA 21-5414 A1C1A, domestic battery class B person misdemeanor. How do you plead to that?
No contest.
By pleading no contest, you mean you're not admitting that you did this, but you don't want to deny it and take it to trial?
Yes, Your Honor.
Is anyone making you enter this plea today by threats or promises other than your plea agreement?
No, Your Honor.
Do you understand that with this plea, you'll most likely be found guilty,
Yes, Your Honor.
having waived your right to a trial and not able to appeal that conviction?
Yes, Your Honor.
All right, Mr. Regier, you have a factual basis to support this no contest plea?
Yes, Your Honor. Pursuant to the information, count one alleges that, quote, on or about the 16th day of April, 2025 in Butler County, Kansas, the defendant Brandon Lee Branscombe did knowingly or recklessly cause bodily harm to another person who is identified as the victim in this case, a person with whom the offender is involved or has been involved in a dating relationship or a family or household member, as defined in subsection E. Were this case proceed to trial, the state's evidence would show the same. Additionally, the affidavit in this case does appear to refer to a past domestic violence disturbance at a location in Whitewater, Kansas. The state's understanding is that is within Butler County boundaries, as well as a reporting physical altercation between the defendant and the victim in this case.
You mentioned an affidavit. Well, the parties stipulate that if this were to go to trial, that affidavit would contain the facts that would be evidence in that trial.
Judge, for purposes of no contest plea, we have no objection to the court using the affidavit.
All right. All right, based on the affidavit, I find there is a factual basis to support the no contest plea, and I do find the defendant guilty. Now, folks, apparently you've worked something out where these folks that have come in from Newton are no longer needed. The Newton officer and Samantha Slater are no longer intended to be called as witnesses. Is that right?
Your Honor, the state's understanding is that upon successfully entering a plea to count one in this case, the state would move in exchange to withdraw the motion.
So are you no longer offering that there was a violation of the no contact order? You're no longer alleging that the defendant violated this court's order by having contact with Danielle Erkson?
Again, Your Honor, the terms of the plea negotiation was that upon successful entering the plea, the state would be moving to withdraw the motion revoking the bond in this case.
Well, you may be withdrawing the motion, but it seems like if we're going to proceed to sentencing, this court needs to know or would like to know if the defendant violated its orders, because that could have an effect on any probation that is made.
Judge, I guess I will speak up that is part of the plea negotiations between Ms. Norris and I, that that issue would become moot and not part of the recommendations.
And that is the state's understanding of the negotiated plea agreement in this matter as well, Your Honor.
Well, plea agreement aside, it's troublesome that a man can be accused of domestic violence battery to a Danielle Erkson, and the court can order that he have no contact with her. And I'm supposed to just ignore that and proceed with plea agreement. That's troublesome. Well, let's hear what your plea agreement is, gentlemen. Sentencing recommendations from the state?
Yes, Your Honor. The state's understanding of the plea agreement in this case is that the state would be recommending a 6-month underlying sentence, the maximum sentence allowed by law for a Class B misdemeanor, as well as a 12 months reporting probation with court services, subject to all standard conditions consecutive to any other Butler County cases the defendant may be currently supervised on. The state would further be recommending all applicable costs and fees, that the court make a determination on the issue of attorney's fees, that the court not impose a fine, but that the court require a domestic violence offender assessment, and that the defendant be ordered to comply with all recommendations, that the court order no drugs or alcohol, and that the defendant be ordered to report today to court services.
Mr. Patterson?
Judge, we're asking the court to adopt the recommendations, including that the no contact order can be lifted upon him getting his domestic violence offender assessment and providing that to his probation officer.
And Your Honor, the state understands after further review of the file that that was also contemplated pursuant to the plea agreement in this case, Your Honor.
This Danielle Erskine, she's his sister, is that right?
Ex-wife, Judge,
Ex-wife.
or maybe common law wife now. They have kids in
Okay.
common.
The kids, okay, they have the kids in
And-
common. Okay,
10 years
what?
together. I'm
You have
sorry,
10 years? You and
we
this
have
woman
10
have
years.
10 years? Okay, and 3 kids?
Yes, ma'am.
When was the last time you saw her?
Oh, the day that I was arrested.
And was that in, is that in
Yeah.
Newton?
Yes, Your Honor.
All right, now, is this Officer Brett Sargent up here on the screen?
Yes, ma'am.
I suspect, though you weren't called by either of the parties, I suspect you have information about this defendant violating the court's order. Am I suspecting correctly?
Yes.
All right. I'm not gonna put you under oath, but tell me, just initially, informally, what the involvement is.
Judge, I guess I have to object because if we're gonna get into a full-blown hearing, I mean, that's one thing, but not to have the ability to dispute it.
Fine. All right, fine. Raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Patterson, I don't know what you guys have going on that you're trying to get around the courts knowing that he's been out violating court orders.
And Judge, that's disputed. I'm gonna tell the court that's disputed. My client would suggest that he's not the one who had invited this contact, that it was not him, so it's disputed, but that's why we've entered in plea negotiations to avoid the confrontation of a hearing.
Mr. Regier, what do you have to say about not wanting the court to know that there may have been a violation of a domestic battery bond or order that could affect, and why it's important now is it could affect his success on probation? Why should I give probation to a gentleman who may have violated the bond? Why should I think he's not going to violate probation in the same fashion? And because a police officer is involved, it makes me think that maybe the bond involves another battery or something. And that's important. So, Mr. Regier, what do you have to say for the state on this?
Your Honor, all I can tell the court is that the state did anticipate proceeding to a hearing today. However, the state is eager to reach a resolution in this case, and all I am aware of is the terms of the plea deal as negotiated between my colleague and counsel for the defense.
Ms. Slater, how are you involved in all of this? Are you an officer? Are you a family member?
No, I witnessed a verbal-ish altercation at the end of April in Newton.
All right, well, I am going to tell you both, I'm not going to sentence him to probation until I know what's really going on here.
Judge, short of getting into a long trial, which is basically what we're talking about, I can tell the court my client was not arrested for a domestic violence event that day. Miss Erskine was, I understand, but my client was not.
Well, why can't Officer Sargent, why do you have an objection to him saying that if that's all it was? I think there's more here than what you guys want me to know. And
I'm trying to avoid a long hearing, Judge, and get
Well,
the
that's
docket done. That's
fine.
exactly what that's a
Well,
purpose.
I'm all about avoiding long hearings that are unnecessary. But I am not going to shortchange somebody's physical well-being and put him on a probation if they've gone out and had another altercation while on bond when they were ordered not to have contact. I'm just not going to do that. So you guys can either have a hearing or I'll just order a sentence without probation. I'm not going to take a chance that somebody is going to get hurt again. And I'm not going to just ignore evidence that's right in my face. So you tell me, Mr. Regier, you're wanting me to do just that? You're wanting me to just ignore that he's apparently gotten into another domestic altercation with her when I ordered no contact? I'm supposed to ignore that? As officers of the court, can you genuinely recommend I do that?
Your Honor, may I request a brief 2-minute recess?
That would be fine.
Thank you, Your Honor.
Mr. Regier, if you're available, I'd like to reconvene. Mr. Regier, we are back on the record in 25 CR 185, State of Kansas versus Brandon Lee Branscombe, all parties as before. All right, folks, I set the bond as my responsibility. I set bonds. As my responsibility, I impose sentences. But before I proceed any further, I have to know what's really going on here. And both counsel have indicated that I shouldn't hear from this officer sergeant. But Officer Sergeant, do you have any information that this defendant violated the bond in this case, wherein I ordered that he have no contact with Danielle Erskine?
I do.
And what information do you have?
On April 24th of this year, we responded to a disturbance between a male and a female. Both the male and the female were located. I spoke with the witness who is here with us today, and she informed me that she watched a man driving a white SUV pull up into the alley near where she was parked. She saw the male exit the vehicle and begin screaming at a woman who was seated in the passenger seat. Upon locating both individuals, they were both identified, and they actually admitted that they had a no contact order in Butler County for a recent domestic violence arrest.
All right.
I also have another issue at hand. Last week, I reached out to the Butler County Sheriff's Office in hopes to get in contact with them to verify whether or not the bond conditions were still
I'm
in
going to
place.
object as hearsay, Judge, unless we have somebody from Butler County here.
I want to hear it. Go ahead.
I did that because I forwarded this case to the Butler County Sheriff's Office based on the information that the defendant had informed me of, that he had bond conditions. Last week, they were in contact again. We arrested.
Hang on. Who was back in contact again? The man and the woman?
Yes.
Okay.
So what he informed you earlier, that the last contact he had with her was the date he was arrested, and was untruthful.
Okay. All right. So the man and the woman in the truck, do you know who they were?
It was Brandon Branscombe and Danielle Erskine.
Okay. I didn't totally follow the Butler County thing. You contacted Butler County and told them what you had in Newton?
I tried to. I asked our dispatch to send a teletype, basically an email to the Butler County Sheriff's Office, to have one of their deputies reach out to me so I could verify whether or not the bond conditions were still in place.
And the result?
They did not reach back out to me. They did not call me.
Okay. All right. Okay. Ms. Slater, please raise your right hand. Solemnly swear the information and testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. Now, what can you tell me about anything that has to do with this Butler County case involving the defendant, Mr. Branscombe, and the victim, she's now determined to be the victim, Danielle Erskine, What can you tell me, if anything?
Sure. The only thing I can tell you is what I saw. I believe it was April 24th. I was in Newton for a work-related reason, but was sitting in a parking lot at the Dillons, and in front of me, a white SUV went into the alleyway that was in front of me, and I saw a gentleman exit the driver's side of the vehicle, shut the door, seemed flustered. I could not hear anything that was being said at all. I didn't have my windows rolled down or anything. I was just going off of visual. I could visually see that he was upset. He was yelling at the vehicle. And then after a little bit of time, I don't know exactly how much, he went to the passenger side. And then the passenger side door opened. He did not open it, but it did open. A woman got out. And then they were having a verbal altercation. They walked behind the vehicle, and then I saw her put her hand on his arm, kind of like a, hold on a second, come back kind of thing. And, he pulled his arm away, and he was still yelling at her. I couldn't really tell what her demeanor was or her reactions or anything. She did have her hands up a little bit, kind of like, whoa, hold on a second kind of thing. And then he continued to walk. He did pass the car. She did get into the driver's vehicle, or the driver's side of the vehicle. They were kind of following each other down the alleyway. There wasn't a whole lot going on at that point. I could still see that he was, agitated. He was still yelling at the vehicle. They did stop a couple times. I never saw her exit the vehicle again after she had got out of the passenger side. And then they had come to a street. I don't know Newton super well, but they did come to a street. The back hatch of the vehicle opened, and then it closed. I didn't see if anything was taken out or anything like that. And then they did continue to drive down the street. And then when they passed, I believe it's Main Street in Newton, I couldn't really see them after that. I saw her pull into the Little Caesars parking lot, and then I was kind of done with it at that point. I couldn't see anything anymore after that.
Did you report that at any time to law enforcement?
Yes, I called 911 just shortly after she had put her hand on his arm.
All right. Thank you.
Yep.
Officer Sargent, you're the one then that took the report and worked it?
There were, I believe, 3 of us working that specific case.
Have criminal charges been filed against either party, the Branscombe or Kirkson? Do you know?
Yes, both of them went to jail that day.
Okay, and do you know if the prosecutor filed anything formally yet?
That I'm not sure.
Okay, all right. Okay, well, thank you both very much.
Judge,
Now,
I have a question for the officer.
all right, go ahead, please.
Officer, you said both of them went to jail that day. What were the charges against each of them that they were arrested on?
I believe Brandon was for driving on a suspended license, and the Danielle was for domestic battery.
Okay. Mr. Branscombe was not charged with domestic violence or arrested for domestic violence at that time. Is that correct?
Correct.
That's all I wanted to clear up, Judge.
And let me follow up. Okay, driving while suspended against Brandon, and what did you say against Danielle?
Was for domestic battery.
Okay, all right. Mr. Regier, you have any questions of either of these two?
No, Your Honor.
Did you have any for Miss Slater, Mr. Patterson? Okay. Well, folks, I am going to take this all under advisement. Mr. Branscombe, your attorney may not want you to talk right now. I don't know. He wants to talk, Mr. Patterson. Do you want to let him?
I will talk with Mr. Branscombe later, Judge.
All right. I am going to set over the sentencing on this. Now, the problem is I'll set the sentencing over 1 week. I know I'm gonna squeeze another one on you. Can we put that at 1:30? 1:30 by chance, Jen, on Wednesday? No, that can't do that either. Never mind. Let's put it 9 a.m. Monday, and the defendant must be present at the Butler County Courthouse unless his bond is revoked. And at this time, I'm going to revoke his bond You
And
need
Your
to
Honor,
turn.
Your Honor,
Mr.
as indicated on the record, the state has withdrawn its motion pursuant to
I
pre-negotiation.
understand, and on my own motion, Mr. Branscombe, where are you at this moment?
I am waiting to enter into a inpatient facility. I've got my assessment and everything. My bed's
I didn't
waiting.
ask you what you were doing. I said, where are you? What town are you in?
I'm in Wichita, ma'am. Your Honor.
Wichita? All right. Are you in a residence? Are you in a treatment facility?
I am at a residence and I'm waiting for the court to be done with so I can go into my inpatient. They told me if you guys needed to speak with them on the court's behalf, you need to speak with them to verify that, for me to give you their number and they would verify that.
What are you going into treatment for?
For drugs and alcohol, Your Honor, I have an addiction problem and I mean, I need to get it taken care of.
So you couldn't even report to probation. You're not even ready to start reporting to probation. You're going into treatment.
Yes, I mean, yes, Your Honor, I feel that getting myself for.
How about batter's intervention? Have you done an evaluation for that yet?
No, ma'am, I started mental health and med management through Prairie View in Newton. And I've been working with CCRT. I don't know if you're familiar with them, but they're out of Newton, Harvey County. And they have, I'm sorry, they also have the BIP program there at their location.
Okay, so you violate bond. You work out this nifty plea agreement with the prosecutor that you don't have to face any consequences for not only violating bond, but going out and getting into a confrontation with the victim. And then instead of reporting to probation, you're telling me, or going to jail, as I could order you, you're telling me, well, I went out and I got myself into an alcohol and drug treatment program. Although the issue in front of this court is domestic violence, it probably is aggravated by drugs and alcohol. Counsel, I feel like you've brought me an impossible situation unless I just order the police to go out, pick him up, put him in jail, and let him serve 6 months. I feel like I have been manipulated to the utmost in this case, and that's not like either one of you two to do that to me.
And Judge, I guess I take offense to the word manipulation. These are standard plea negotiations that I've entered into with the state. So yes, have we entered into a plea negotiation that was to leave out information from the court? Yeah, that's just standard plea negotiations, and that the court has on its own retrieve that information. Well, this is Your Honor, this is your court. I can't really stop the court from doing that since the witnesses are right here. But I think it is a plea negotiation that was warranted and well thought out, and one that we presented to the court.
Well, and I appreciate your offense, Mr. Patterson, but here's why I see it as manipulation. You weren't going to tell me that he was having contact with this victim of abuse. You weren't going to tell me that he was screaming and yelling at her to the point that a citizen called law enforcement and law enforcement came. You weren't going to tell me that he was seen driving while his license was suspended, which is a violation of the law. Bond says don't violate the law. Bond says don't have contact with this woman. Then when I get to sentencing, you've got him signed up to go into an alcohol and drug treatment program that nobody told me about, but it would circumvent reporting to treatment. And what about that statute that says he has a mandatory 48 hours and a mandatory $200 fine, which I can waive if he does the BIP intervention? But he's not set to go into BIP right away. He's set to go into alcohol and drugs. That to me looks like manipulation so that he doesn't have to serve his sentence, that he doesn't have to have any consequence for violating bond manipulation that he doesn't have to have any consequence for what happened in violation of the law while he was on bond. I mean, driving while suspended, that's a B misdemeanor, a crime. And I'm not supposed to know about any of this. Let's keep the judge from knowing this. Mr. Patterson, that to me looks like manipulation. Maybe it's not. Maybe you don't see it as that. And I respect you as an attorney, and I have for many years, and I respect Mr. Regier as an attorney. And I have for not as many years because he hadn't been at this as long. But this is highly troubling to me that I'm seeing this. And if this is standard, and I haven't seen it before, and I'm being duped by it, that's alarming. Because judges are supposed to know what they're dealing with when they make a sentence. And how's Mr. Branscombe going to deal with this? Again, this is outside of my jurisdiction, but at the same time, what he does in other jurisdictions should affect what he does in this court on probation or as such. But if he's facing driving while suspended charges, but he can't go because he's in treatment.
I don't know that he is, Judge. I haven't seen any charges filed in the city of Newton.
Fair enough, fair enough. And I know that if they need alcohol and drug treatment, that's a very big, important priority. Unless it's designed as manipulation to skirt consequences. Was there even an evaluation, or did I understand him to say he just went and signed up for it?
Judge, I can tell the court this was the treatment program was not part of this case or part of the negotiations. That is something he's doing on his own. This is the first I've heard of it. The batter's intervention program, on the other hand, is something that was part of the plea negotiations.
Mr. Branscombe.
Yes, Your Honor. I just want to say that I did get a evaluation. Actually, I got several of them over this last about week and a half to try to find the earliest opening bed that I could so I can get into treatment sooner than later. And the one that I found was supposed to be today at 9 o'clock in the morning. I had court at 9, so they extended it till 1. But I have another, they said that it would be okay if I came in tomorrow. If it doesn't work, they told me to give the judge their contact info and that she can contact and talk to you and tell you about, how I came about getting there and everything else. I'm not trying to manipulate you, Your Honor.
Mr. Branscombe, this allegedly occurred April 16th. Well, this did occur because we found you guilty. April 16th, 2025. What motivated you between then and today, June 9th, 2025, to go out and get this evaluation?
Well, the loss of my children that were taken from me and my wife not being able to have contact with each other.
But you have been having contact.
I have. I'm not going to completely lie to you, Your Honor, but it hasn't been like it was. Like we're a family. We live together. We're with each other every day. We're a family. We have a business together, and it's gone from all of that to, and all of a sudden, in one waking moment, my children were taken away. I wasn't allowed to be told where they were. My wife I was told I couldn't have contact with her. So there goes my work because I don't have a valid license. She was the one who drove us, and she was my helping hand in our business. I mean, we have a LLC. We've been open for 3 years, and it's just all of these things were just all at one time. And I just came to the realization that, when we were clean for 7 months just recently, we got off the drugs and we were clean for 7 months. We didn't argue one time, Your Honor, like not one fight. I mean, nothing. And it was awesome. It was amazing. And then we relapsed, and things got worse and worse and worse, and I recognize what it is, and I know that I can't get my family back without me getting myself clean. And it's been on my heart and my mind that I've been thinking about it over the last month and a half, 2 months, and it's time. I want my kids back. I want my family back.
Did you make this appointment after you had contact in Newton with law enforcement?
Yes, Your Honor.
So it wasn't the domestic violence in this case that was the final trigger to make him do the appointment. It was this second contact?
Yes, it's just that it wasn't
All
the
right.
domestic.
It wasn't the domestic. Go ahead.
It wasn't the domestic per se. It was just me coming to the realization my family's been torn apart and being held away from me, and it's all due to my usage and being an addict. And I wanted to get it fixed and then get it right. I don't want to lose my wife and my kids.
Well, you're saying all the right things.
I mean,
Okay. When's your next available bed?
Today
What time?
it was at 9 o'clock, but they said they can push me out until 1 o'clock
1
for them
o'clock.
today. Yes, ma'am. And if I can't get in there by 1 o'clock, that they want to be able to get me in through the rest of the day. That tomorrow morning to be there at 8.
This is alcohol and drug treatment. What was the facility?
It's Cherry Creek.
Cherry Creek. Okay. And it's in Newton?
No, this is in Wichita.
And it is inpatient for how long?
I believe it's a 30-day program.
You don't know?
I haven't got all the fine details. I mean, they sent me the
You were gonna-
pamphlet.
You were
I'm
going to
sorry.
go check into this facility without even asking them how long the program was?
I need it, ma'am. I mean, if it's 30 days, 60 days, it really don't mean a lot of difference to me as long as I'm getting what I need to and getting some clean time back under my belt and getting back out here for my family.
Well, I cannot tell you how many times I have seen someone who gets into your position use treatment as a hiding, as a manipulation, as a way to avoid consequences. Whether you're
Yes.
doing that or not, I don't know. You sound, like I said, you're saying all the right sounds or words. You've got the right inflections. I am going to withhold your sentencing until you complete your treatment, but it better be inpatient.
Yes, Your Honor.
And you contact the attorney as soon as you get close to your out date.
Yes, Your Honor.
And I'm going to get you right back in here as soon as possible for your
Yes, Your Honor.
sentencing.
Yes, Your Honor. Thank you.
Is everyone clear on that? We'll
And Judge,
continue.
I guess what I'd ask him to do is when he goes to the treatment facility, that he have them send me a report stating he's admitted and what his out date will be. That way we know a little bit sooner than just when he's released.
Yes, do that because Mr. Patterson, then if you'll get that to me, I'm going to set the hearing in relation to when the out date is set to be so that I don't just drop the ball waiting for him to contact us because we know that that would not be a wise decision.
Yes, Judge.
But but in the meantime, I'm still going to set a date, just a control date, Mr. Patterson, but I want to change it. What do we have, Jen, about 30 days out?
1 moment, Your Honor, I'll look.
Okay. And it could be that if it's a 30-day treatment program, we may end up getting lucky and setting it now, but. And why isn't the victim here, Mr. Regier? Did she have notice of this hearing?
One moment, Your Honor.
I'm going to, Officer Slochet, Ms. Slater, you are welcome to stay to the outcome, or you're welcome to go. We've used so much of your time this morning. I want to thank you for being here. I want to apologize that you've had to wait so long. But I'm going to leave it up to you if you want to stay or go.
Thank you.
You're welcome. Thank you.
Your Honor, the state's information is that there has been contact between the victim and my office as recently as within the last 2 to 3 weeks.
Well, make sure she's given notice of this next hearing. It would be helpful to hear from her. Okay, Jen, did you find a date about 30 days out? July 7, 9 a.m. This matter is continued for sentencing unless, Mr. Patterson, you find out something closer. I don't want him out before I see him again. I don't want him, but you are still on bond. You are not to have any contact with her, Mr. Branscombe. You are not to violate any laws. You're muted, sir.
Yes, Your Honor. I understand.
All right. Anything further from anyone?
No, Your Honor.
Not from the state, Your Honor.
Thank you. Get to treatment. You better be there at 1 o'clock or it's a violation of your bond.
Yes, ma'am.
All right. And get proof to your attorney.
This is 25 BE02536. The citation was issued on the 17th day of May at about 5:16 in the PM in the area of Berkeley near Oxford and Stanford Streets. You were cited for disobey a stop sign. You have three options. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Not guilty.
That wasn't one of the options, but put this down as denying responsibility. If you raise your right hands, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
I do.
The officer will testify first, please.
All right, Magistrate, on 5/17/25 of this year, approximately 5:16 p.m., I was just conducting neighborhood patrols down the street of Stanford when I came across Oxford. I observed a 2018 Kia Sportage, red in color, make no attempt to stop at the stop sign that would be, it'd be eastbound Oxford at Stanford, went right through the stop sign in front of the patrol vehicle. I then made a traffic stop on the vehicle, observed the plate Boy John George 622, and made contact with the driver, Miss Emily House, I believe, if I mispronounced that name. Right then and there, spoke with the driver and alerted her to the reason for the stop, which was disobeyed the stop sign. As I came back with the citation, Miss House told the officer that she hopes I get shot today after presenting the citation. And I also have the patrol car video of that, or the dash cam, if you're interested in seeing that.
Ms. House, it's your turn.
Awesome. It was Berkeley Day garage sales, not the Berkeley one, but when Huntington Woods has theirs, Berkeley always has
Ma'am,
things.
I'd really like to know what happened.
That's why I'm explaining. It kind of shows how
Oxford and Stanford.
Oh yeah, I'm saying my part to how there was people blocking the driveway just a little bit before when I was driving. Like it was pretty busy, and just at that little bit where the Stanford was, there were short shrubs, and the officer, I would say, was more than 2 streets, if not 2.5 streets back. I definitely stopped before, I guess not exactly at the stop sign. With the shrubs, I don't think he possibly saw that, but I slowed down. I guess it wasn't the absolute 3 seconds, but it was enough that I even remember looking left and right and then continued. I remember going 25, going halfway down the street, and then he turned. So that kind of shows how far back he was. And then we were talking and he said, I ran the red light. I corrected him and said it was a stop sign. And then he walked away and came back with a ticket without any more explanation to where I could talk and say, I kind of think you were wrong here. He was already holding the ticket in his hand, and I was upset, and I said that. I was very frustrated that I could not speak to him, and immediately on correcting him that it was a stop sign that we're talking about, not a stop light, I got issued a ticket, even though what he said was wrong. And this was my first offense ever.
No, ma'am, it was your first offense that you've ever been cited for.
I've never been pulled over. The only
That's what I said.
was pulled over is when I was 16. When
if you listened to what I'd said, you wouldn't be contradicting me.
But being reminded to turn on the lights from turning on to Woodward is not doing anything wrong, because
So you have been stopped.
The lights were turned on.
So
Like
that's
one small thing when I was 16. I'm 26 now, and there's been nothing for 10 years, while some people have issues back to back. I think that does say something, sir.
And some people tell policemen they hope they get shot today. I have never, ever heard of such egregious conduct by a driver.
Sometimes I thought it was very wrong that I wasn't able to say anything.
Unbelievable. You're trying to justify.
I think it's unbelievable that he said something wrong I corrected him, then I don't get to say, I get slapped with a ticket for saying we're talking about a stop sign here. I don't think that's fair either.
I'm going to stop a second because I want to deal with what you've said. You've talked about the area being pretty busy. You've talked about the fact that
earlier that day due
listen
to the
ma'am,
garage
I'm
sales.
trying not to interrupt you. I would wish that you would at least comport yourself as an average, courteous person.
Yes, and a courteous person would understand the situation, and the situation was busy prior due to the garage sales, and that's why I was in the area, because I just bought my house. I'm low income looking for items. I am setting the scene for why I was there, and I did not run the stoplight. This area was not busy.
There was no stop
things on the side of the road.
You've told us that there was no stop sign light there. Now you're telling us that
He was saying it was a stop light. It is not.
You just did the same thing.
But it's
exactly the same thing. Now you testified that the officer was.
Hey, it's a stop sign that we're talking about.
Would you slow down the mouth a bit?
There's nothing
to
slow down.
Talking,
you're trying to set the scene.
Stop
and you're
talking.
switching my words saying stops light. I corrected him. He walked away.
Would you stop talking, please?
Sure. I just think this is unfair.
Would you stop talking, please?
Okay.
You testified that the officer was 2 to 2.5 streets back, and therefore he couldn't see you. Okay. How is it that you could see him and he can't see you?
Because I remember slowing down and looking left and right. If I fully missed
that wasn't the. You're not responding to the question.
So
I said
down.
if you can see him when he's 2.5 streets away, why is it that you think that he can't see you?
Because they had those nice smart shrubs all the way
across. We have one-way shrubs. Berkeley's got one-way shrubs. You can see through them, but nobody else can.
That's not what I'm saying, Your Honor.
It is what you're saying.
Shrubs the size of. I was saying previously, when you slow down to the stop sign, which I did,
you slow down. Okay.
We're looking at half shrubs. He does not see the car edging out. I'm saying I stopped slightly prior, edged out. There was no one there. The cop I saw was 2.5 blocks down. So then I went. I still am going 25. I'm looking at things on the side of the road. It's garage sale. I'm halfway down going the speed limit, and then he turns the corner. That kind of shows how far down he was. It is not one-way shrubs. It is the short shrubs to where you cannot see the Kia leaning up into, and I stopped prior, so I'm stopped. There's no one there. I go, and there's shrubs at least a good 1.5 feet after that, because they go all the way to the corner. And then when I was honestly, I thought he was going on to Woodward, and I'm like, you're pulling me over, but you were so far back. So after being so far back, and then he was wrong about the stoplight and stop sign, so I correct him with that, and I just get hit. It's like, when I don't think that's fair.
You know, we've heard this 3 times, but it doesn't get any better with retelling. It's just as illogical every time.
That's what makes me so mad is I remember.
I know your lack of logic would be very frustrating.
And then looking at this side again, so I at least stopped for 2 seconds.
You didn't stop for 2 seconds. You
I
said
did. How do
you
you
slowed
look
down.
left, right, then left again? That's at least 1.5.
And look both ways.
Yes, and that's what I know. And I looked and I was like, oh, he's all the way down there. I can go. Why would I pull out?
Did you hear what you said? Maybe you should listen to yourself. You said you slowed down and looked
I saw that
he
was all the way down there, and I went ahead. Maybe he saw me step on the gas because I was excited because I saw something on the side of the road that I can't even remember what it was. But I remember slowing down, looking this way, saw there was a cop, looking this way, continued going 25, and then made it halfway down the block.
And what you've described is what a driver's legal obligation is at a yield sign. Yield signs have 3 corners and they are yellow. Stop signs have 8 corners and they are red. When you come to a stop sign, it is not your obligation to slow down and look both ways. It is your legal obligation to stop.
And then you look both
You
ways.
are responsible. The fine is $150. If I could raise the fine, I would. If I could raise the points, I would, but that's not available.
Oh,
And
sounds
your
great.
conduct to the
Sounds great,
officer,
sir. So I guess
your
this meeting's
conduct to the
adjourned then.
officer
Sounds
is
good.
unbelievable. That
I
a
think you're
person who lives
unbelievable.
in Oakland County would talk the
Well, I
way
guess
you
I
do.
don't have to listen what you have to say since you weren't listening to my side.
Ma'am,
Sounds
I've listened to
good,
what
sir.
you've said at least 4 times.
You
have just
haven't, because
repeated
now,
the same
but I
illogical.
slowed down, I stopped, was able to look like there.
Yeah.
It wasn't like I was going this way and then while moving, I am halted, looked both ways, and continued. How I don't get how he didn't like. Can we see the clip? Can we see the clip from the car? What can he see being all the way down? That's what I'm more intrigued on, because I was shocked that he was pulling me over because I was all the way down.
You were shocked because he pulled you, and
Going
all the other
25.
people around you were worse.
I was cruising, listening to my music. So that's why I was like, oh, it's me. You're not going on to Woodward. And he's like,
listening to your music. You were looking for
yes, like I'm
garage
enjoying
sales.
I just babysat for 5 hours. I'm trying to relax in my Saturday, look for things for my house on the side of the road. That's why I'm like, it's me.
If I can interrupt you for just a second.
Mad. I remember stopping.
I want to
and then I
interrupt
was
you
like,
just
oh,
for a
there's
second,
cop
if you don't
all the way
mind.
down there. Let me look to my
This
left
house-
again.
Stop talking. I want to interrupt you for a second. If you give me a moment, you're responsible. Pay your ticket. We're done.
See ya.
I hope not. At least if you're driving.
Sorry, magistrate.
I hope you get shot today. Can you imagine saying that to a human being?
Yeah, that was the demeanor from the get-go of the traffic stop. So that's why there was no further conversation.
Cheating.
It was also yelled multiple times as she was pulling away. That was the one. She just all the way to Woodward, just everything she could yell at me through the window. So she was a very pleasant person.
You know, I wish kids that are learning to drive could see and watch the traffic court, because they would become more aware of what they're sharing the road with.
Absolutely. And the sad part is it could have went a totally different way. You know, she set the tone for that traffic stop.
Telling you that she hopes she gets shot, that's not a great start.
No, I would agree.
But to think those words about another human being, I hope you get shot today.
Yeah.
And she had no remorse whatsoever.
Oh, no apologies.
It was my intention, as I reviewed the tickets before I called the case, to give her an opportunity to apologize. I must have been on Space Mountain to think that was a possibility.
Yeah, unfortunately, from the interaction at the traffic stop, I kind of knew what was coming our way. So I apologize for not giving you that stuff.
No, I had read your remarks.
Okay.
So, wow. I don't think if I was Ms. Joan DeSalvo that I'd want to be next, but unfortunately somebody has to be. And we'll. And we have 7. This is 25 BE 02168. Mr. Salva, you were cited for speeding back on the 28th of April, about 9:30 in the morning, in the area of Berkeley near 11 Mile and Thomas Street. The ticket was issued at 40 and a 35. You have 3 options. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Good morning, Your Honor. I would like to admit responsibility with an explanation, please.
And what is that?
Actually, I guess that's the correct term for that. I take responsibility for speeding, but I'd like to kindly ask if you would please allow me to pay the fine, but waive the points on my record. I have a pretty...
The court doesn't give the points. The points have nothing to do with the court. The points are issued by the Michigan Secretary of State. Every particular civil infraction, traffic-related civil infraction, has a point value that's preset by the secretary. And whenever that infraction is abstracted to the secretary, it gets the same number of points for the driver no matter where the court is. Is there anything you want to add to this, officer?
Yes, magistrate. It was nothing but cordial upon the traffic stop. Is there any way I can amend this to impeding traffic for her so that'd be the points?
Certainly. Mrs. Salvo, the officer's motion is to change the ticket from speeding to impeding. Impeding does not carry points.
Thank you very much. That's very, very generous of you. I truly appreciate that.
Absolutely. Thank you for being courteous on the road.
Of course.
You know, I've never understood not being courteous to someone that is a police officer and has a gun. And I just don't get it. But
you'd be surprised these days.
Oh, I wouldn't, because I hear it. But
yeah, I'm sure you do.
It's what's sad is that somebody being polite and courteous becomes noteworthy.
Yep.
Especially in this day and age.
Yeah. Well, that's the good news about impeding. The bad news about impeding is it carries a fine of $175.
Okay.
Which can be paid online or by mail or at the courthouse counter, whatever works for you.
Okay. All right. Thank you so much. I really greatly appreciate you hearing me, and officer, I appreciate your generosity. That's extremely extreme relief to me. So thank you.
Absolutely. You have yourself a good day.
You too. Thank you.
Thank you.
All right. Bye-bye.
Court that's called the case, Beaver State of Michigan versus Ryan Music.
Alexander on behalf of the people, Your Honor.
And good afternoon, Your Honor. Miles Drew on behalf of Mr. Busick, who is standing to my right, P number 84554. Mr. Busick, could you please state your name for the record?
Ryan Michael Busick.
And Your Honor, I do believe that your staff should have in their possession by now a substitution of counsel. I was retained yesterday on Mr. Busick's case, and I believe I have received all the documents the public defender's office had from the prosecutors related to their motion.
You have this.
I'm looking to see if it's a JIS. I have not received.
If you don't, I do have a blank copy. It appears my staff had the judge's name wrong, but I do have a blank copy that I'd be able to sign and provide to the court now.
You see it?
No, I do not see it.
84554.
Mr. Kearney, could you sign off on
Yeah.
on that?
Okay. Yeah, happy to put it on a CAO form. Okay. Have a nice one. Your Honor, may I approach?
Yes.
Oh,
Well, that's okay.
thank you, officer.
Gotcha. Okay. I will sign off on that, but we can proceed at this point. All right.
Thank you, Your Honor.
This is the people's motion. You're prepared to argue it at this point?
Yes, I am, Your Honor.
Counsel, did you receive copies of emails that your client had been forwarding to the court? I think we sent those to the prosecutor.
Correct. I believe that was yesterday.
Yes, I'm in receipt of one email to the court, a copy of the prosecutor's motion with one exhibit attached to it, and then a copy of the police report and the information.
Well, I don't know what point you got that, because there were 3 emails to the court.
Oh, there was. I am only aware of one email.
Video attached.
And
I have the one with the video attached.
There were 2 after that.
there were 2 after that.
May we briefly go off the record so I can review these 2 other emails, Your Honor?
Yeah, what are the, did you have copies of them?
What was that?
I have copies, Your Honor.
Okay.
Email.
Can we, no, here, well, I've got our copies, so I'm gonna step off then so that he can go through that and talk with his client before we continue on.
Thank you for that opportunity.
Court stands in recess. Go ahead. This is your motion.
Thank you, Your Honor. At this time, people are going to be requesting our original request of a $50,000 cash surety bond. In this case, defendant was granted a PR bond. However, the facts of this case are extremely concerning to people. In this case, the defendant went to the victim's residence and was almost interrogating her and accusing her of infidelity. He banged on the door, was told to leave by her. He then forced his way into the home, breaking the door. Officers, when they arrived, saw broken drywall, the door was off the frame, the lock, the deadbolt was still in the lock position. After entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her about infidelity. She was then able to kick the defendant, run away out of the room, and exit the home, where she began to yell for help. Neighbors heard her calling for help. After that, the defendant then chased her down and tried to stop her by grabbing her arm, causing her to fall. Law enforcement arrived shortly after, and in the videos, see that they both, it was raining and they were both covered in rain and I guess water, I don't know. But it's very concerning, especially given that there was the broken door. And then not only after that, when he gets into custody, one of the two calls he makes, while one of them was prior to bond conditions, it was concerning to the people, given that in that call, he continues that line of interrogation of accusing her of cheating and infidelity on the jail calls. And then the next day, when he's arraigned, after he's arraigned, he calls her again, violating his bond. And it just seems, especially given these emails that we received yesterday, he has this obsessive disposition with this victim, and it's very concerning to people given the facts of this case and his actions after this case occurs. So at this time, we're going to be re-requesting our $50,000 request, and believe that a personal recognizance bond was an abuse of discretion, Your Honor.
Ms. Rhodes.
And Your Honor, we would admit that there was a call that occurred on the jail line, the one call that is a violation of the court's bond conditions for the no contact. I would note that all the allegations the prosecutor has gone over as it relates to the bond violations were prior to me being retained as counsel. Mr. Busick's a lifelong resident of Ypsilanti. He has a clean eye chat that I've seen, meaning he has no priors and accordingly no capious history. While this is a very serious charge, and Mr. Busick does contest the allegations and is serious about facing them as evidenced by retaining counsel, I would note that there was no injuries or medical treatment and that Mr. Busick did comply with police officers. While I'm not here to litigate the facts of this case in a bond hearing, I think it's evident from looking at this case and the pending case against the complaining witness, where my client is the victim, that they have a dysfunctional long-term relationship that will no longer work out in any capacity as a romantic relationship. I've expressed that to Mr. Busick, and he's been receptive to that feedback. I think it's clear that neither party has treated each other very well. He is living currently in Ypsilanti with his mother, Lisa, who's in court today, his stepdad, Doug, who is also in court today, sister Chelsea, who is not here, but has been in constant communication in my office. His sister Erica is here in court, so he has strong family support in this matter. He does have two children with the complaining witness in this matter, his son Matthew, 4 years old, and daughter Scarlett, 2 years old. It's a shared custody situation where he has the kids on the weekend and about 2 or 3 nights during the week. His mom and sister are facilitating those custody exchanges, and I have expressed not only to Mr. Busick, but to the family, the importance of the no contact order, including that it means no third party contact, and have instructed the family not to discuss this case in any capacity whatsoever with the complaining witness. As for work, Mr. Busick is a journeyman carpenter with the Regional Carpenters and Millwright Union. He has over 10 years experience and 6 years with the union. He has good health coverage through his job that provides for not only him, but his children with the complaining witness. It's our understanding that the complaining witness does not work. And even though there's no child support order in place, he does also provide support to the mother of his children for expenses when she has the kids in her possession. In other words, he is the provider for these children, and they get their health insurance through his job. And that appears to be the only avenue for their health insurance. And he is at risk of losing this job should he go to jail. So, Your Honor, I would, conclude by saying that counsel was retained after all these allegations, that Mr. Busick has no prior criminal record. And I think him and the family maybe didn't understand the scope and importance and severity of a no contact order. I have counseled them at length about that no contact means for
What
any
wouldn't
reason.
yet you have understood about that, counsel?
Your Honor, I think it's somewhat common for people. I know no contact means no contact, and it's very straightforward, but I think people that have no prior history with the criminal justice system sometimes do not think things are as straightforward as they are. He certainly makes no excuses for his behavior, and he knows it's inexcusable to make those calls. We would be asking for a 25,000, 10% with the tether.
But he's still, I mean, from the allegations, I mean, and I'm not making necessarily a presumption of his guilt of those, but he's making certain allegations regarding her infidelity, then ultimately gets arrested. I mean, after creating, I guess, some damage or allegedly creating some damage to the premises, and things not going well because now you're in custody, you're told by the magistrate not to have contact, and what does he do? He has contact. And about the same thing that the allegations are about.
Right. I understand the court's concerns. That's why we are asking for a cash bond in this matter. I would point out that, since he was assaulted in March by the complaining witness, which resulted in felonious charges, these have been some of the hardest and trying months of his life. He has not been in his right state of mind. We're going to be looking to getting him, treatment while on bond and getting evaluated for a treatment course so he can get some support in facing this tough time, Judge. Ultimately, there's no excuse for making the phone call on bond. We understand that the allegations are concerning. We can test them as it relates to the case.
Tell me how I can even be sure that he's going to follow this court's conditions.
Well, I think you have his family sitting right here in the courtroom, that they're accountable, good members of our society that are going to be looking out and holding him accountable. They have, financial interests involved in this case as well. They are living with Ryan. He has no prior record, which I think speaks to the fact that they raised him pretty well up to this trying point here. And I think that the tether, was put in place after these phone calls, and there's been no issues with the exclusion zone. So I think in that respect, the tether is working, Judge. And I think you have members of the community that will be looking out to ensure that your court order is followed by Mr. Busick. And I think this is a real wake-up call for him, quite frankly. This isn't a situation he's used to being into, given his clean criminal record. And I think he's standing up a little bit straighter now after this and understands just how much is on the line after having a stern talking with counsel both last night and prior to court today about the severity of the situation that he's in here, Judge.
In the 14B case, isn't there a no contact?
There is a no contact order in place.
So what's he doing there? I mean, that's the part that's troublesome to me. He has a case in which he's the alleged victim, right, counsel?
Correct.
He knows there's a no contact provision, right?
Yes. Well, the no contact provision would run to the defendant in that case, which is the complaining witness in this case.
How it works. That's not my point. My point is, why is him knowing that? Why is he at her residence?
Well, Your Honor, I would say that I think, these no contact orders, I mean, he shouldn't have been seeing her, but this is a 10-year relationship that goes back to when they were 16 years old. They have children in common. While I certainly would have liked if this was handled different.
That's all fine and dandy. But he knows she's not supposed to have contact, right?
Well, he believed the condition was dropped. But I mean, I would agree that he should not be having contact whether it's a.
You get the idea that it was dropped.
I'm not sure, Your Honor.
I don't believe that for a minute. I mean, he knows she's not supposed to. I mean, I'll tell you what it sounds like to me. Sounds like to me he's intending on getting the upper hand. So he goes over there and he can basically, in essence, force her to give whatever answers he wants, because the one thing at least he knows or thinks is that if he calls the police, she's in violation, I'm not.
No, I don't think that that's the situation going on. I mean, when the police officers did bring up the no contact order on the scene, he said that he had thought it had been dropped. I mean, I think he's simply concerned about, these beliefs of infidelity, Your Honor. It's an improper way of going about it without doubt. But given that he has no record, he hasn't had any trying situations. He's only 26 years old. Any trying situations like this in his life, I would view this as kind of a one-off situation, that now that he has the accountability structure in place with his family, being aware of what's going on, being in the courtroom here supporting him, that this type of behavior would not continue. And I expect him to comply with all court orders going forward, Judge.
Anything else from people?
Nothing, I mean, I just have concerns given what the court stated with the no contact order in the 14B case, and given that the victim in her interview with police at the scene states that they're separating. So I don't know why he would go to her residence to accuse her of this break-in and assault her. I just don't understand. But nothing else from the people as far as this goes, Your Honor.
All right, and I think you know this, counsel. What I really should do is I should revoke his bond. He doesn't make it a day before he's violating the bond condition.
I understand the court's concern.
It's not. What is troublesome for me is that he violates the bond condition. And when you look at the transcript of what he's talking about in the very first part, it's just a continuation of what got him there in the first place.
And I think sorry.
Go ahead.
I was going to say, I think the stern talking to that I've had with both him and his family about the, concerning nature of these allegations, the phone call transcript, I think that he's been very receptive to my feedback, and I don't see that this being an issue going forward. This was, within a day of the incident, his emotions were still very, high in charge. It's obviously no excuse for doing what he did, but given that—
Counsel, that's part of my problem. Part of my problem is it doesn't seem that he can de-escalate, because he gets involved in this thing, gets arrested. This fixation that he has on this infidelity, even after he's arraigned, even after he's warned, admonished what he can do, what he can't do. Within hours of that, he can't step back. He just can't.
I understand the court's concern. I would say, while I would not have advised him to send any of those emails to the court, the fact that he's reaching out to the court, not to her, is some indication of change from the, Friday before.
No, it's really not.
He's not reaching out to her. I certainly would not have advised him to send those emails, and I've instructed him going forward not to do anything like that and to run anything he's doing with these cases through counsel going forward.
Even the emails are concerning. In the emails, he's trying to get her in trouble, trying to use this as leverage against her in the other case. He just can't stop. Even if it's not contacting her, it's this continued obsessive feelings towards this victim.
I'm certainly not pleased with the emails being sent, but I would note that it does appear that there are potentially bond violations on the other case. That's not a concern for this court here. But it's not like he's making up and frivolly.
Why is it even his?
Your Honor, I have no good explanation for that.
Tell me what's your client's purpose in sending those to the court? What was the purpose in sending those to the court?
Wanted to alert them of the bond violations that have been alerted of in his case, Your Honor. It's not anything that he's proud of, but he was going to change his actions going forward.
It's not my court. He knows what court it's in. Why is he sending it here?
I think people commonly get confused about the 14th.
Counsel, look at the very first email. He's not confused because he's real clear about what he thinks is happening with her defaming him.
I meant the confusion about 14A or 14B, Judge. I understand.
But I'm saying, why did he send it here? I'm not the judge. He knows it. He's not confused about what court it is at all.
But I think he did believe he was reporting it to the court of record, albeit mistakenly, Judge.
Is he gonna tell me that if I put him under oath that he thinks he's sending it to the right place?
Yes, he was.
Because I know there is no way. Why is it coming right now?
I sent it.
When were those videos taken? When were those videos taken?
About a month ago. And that was.
She's got a winter sweater on in like May? Really? So if you had them for a month and you think you're contacting that court, what took you so long?
There's no excuse for the timing.
No, what took him so long? This is his story. He's trying to convince me that he can behave.
Would you like me to speak?
Go ahead.
So I didn't want to contact the court because, yes, we were working on things, and I spoke in front of you, and I believe that the no contact was dropped so we could start to work on things. I came in front of you and said that during her case one day.
Your Honor, I would note that it was charged as a felony case, and I know you typically sit on the PCC docket, so you may have been a judge that appeared on that case at some point. My understanding is that currently it is just the misdemeanor domestic violence charge that is still pending against the complaining witness, but I do believe it was a felony case where it's possible you would have been a judge that sat on that docket.
And Your Honor, if the court does remember, you were on that case for PCC's, but the people had declined to address the no contact and change it, given concerns of the case.
You were looking to report these month-old alleged bond violations. Why did the court need to know that now she's defaming you?
I just said there's no excuse for sending it.
There's no excuse for the slander, man.
What?
No excuse for the slander.
Yeah, but how is that a bond violation?
I believe there was an understanding from Mr. Busick that there was some kind of no alcohol or no drug provision as part of her pretrial release order. I believe that's what he understood. Whether that is or is not the case, I'm not sure, Judge.
But then it says, and is now causing defamation against me. Why is that important to the other court?
It's not.
Yeah, it's only important to this court.
Correct.
In this bond hearing.
And I did believe that it was still here. I didn't know it was at 14B.
How come you didn't go through your attorney to send this?
I was not retained at that time, Your Honor.
No, I'm talking, he had a PD at the time. Why didn't you go through her?
I did try to call her that morning after speaking to the prosecutors, I believe. But I was at work and I missed her call back.
When, yesterday?
Yesterday, yes.
So you just decided that you just send it?
Well, yes, so I did. I called the courthouse on my break and I said, you know, where do I contact for breaking bond? I should not have.
Why was it so important for you to report her breaking bond? So let's assume it to be true. Why was that so important right now?
Well, it
careful how you answer me.
Correct. It was
because no.
Detective
Listen,
Paul Thomas.
Why was it so important to do that? You had just received an emergency bond motion to change your bond. You then start sending stuff. Why is it so important to now report what you say is a month old? I think they're older than that. The month-old video. Why is it so important to do that this week?
I wasn't thinking, Your Honor.
Why was it so important? I don't care. What was your thinking? Whether clear or not, what was your thinking?
I mean, I really wasn't thinking. I really wasn't thinking clearly. I'm not too sure.
I suspect the court could hear Mr. Busick there. I mean, he has no justification. He clearly wasn't thinking straight. I mean, I think he was feeling the pressure of the bond violations in this case, was aware that, or thought he was aware that she may be violating her bond. There's no good justification. There's no answer that we're going to provide you, Judge, that
So
ultimately
what
satisfies
makes
you.
me not believe that as he feels the pressure of this case, that he doesn't lash out and do something?
Well, I think his
Why
children.
why would I believe that? He had counsel at the time.
I don't think he had the same trust relationship with that counsel that he has now. And I think knowing how much his children's health care is on the line because of this, because his job is on the line.
It's all on the line. It was
absolutely
on the line after he was arrested. It was on the line when he made that call. It was on the line when he starts sending these emails. It's always been on the line. I don't know why he can't recognize that. And that leads me to believe that no matter what I tell him, he can't do it. If he doesn't understand that from the very beginning, what's at stake. And I do believe that he went over to that unit. He went over there to get her in trouble, just like these emails. That's what he's doing.
No, I don't think that the facts when the case is litigated will show that that was his intention at all, Your Honor. I understand the court having concerns, but I think not only, my talking with him, but now this, bond violation hearing in front of his parents, I think he's going to be standing much straighter. I think he understands it. I wish he was a quicker learner.
It shouldn't take his parents to make him stand up and do right.
And it doesn't, Your Honor. I think that he'll prove that going forward on bond. And I think bond, to the extent that he needs help, he can get better help and services outside of jail than he could inside.
Frankly, they shouldn't have to be here.
Right, and he agrees.
I mean, even if the prosecutor objected, they shouldn't have to be here.
And Mr. Busick agrees. He's embarrassed and shamed by what he is putting, not only himself, but his family through in this. He's not proud to be here today, Your Honor.
When is this BCC set?
Thursday.
12.
So this Thursday. Well, I understand what the people's request. I understand what the defendant's request is. I don't think since he's gotten out until he's called to the carpet, this defendant really does conduct himself appropriately. I don't think that has anything to do with his parents or his family or his upbringing or anything along those lines. He just can't do it. And then start sending, he's got an attorney and he's just sending these emails to the court, accusing her of things. He's in her proximity. He doesn't need to be around her at all. He doesn't need to be contacted. He just continued, and that's the part that is striking to me, is the allegations in this case was that he's arguing about some infidelity. He gets arrested. He goes to jail. He gets arraigned. And at no point after that whole process, after they told him, don't contact her, don't talk to her, he's got attorneys, he's all of those things. What does he do? He calls her again to berate on her. And it's very clear from her responses in the transcript. She doesn't want to talk to him about that. And he just keeps on. And then, if that isn't enough, he then says, oh, okay, well, this is my paraphrase. Well, if you won't answer me, I'm going to try to get you in trouble and get you locked up. So I'm going to send this a month after. He's just playing games. And quite frankly, if he's playing games, he's playing with the wrong judge to play those games. Defendant's bond is going to be set, and the court is going to find on two bases. One, his violation after the bond terms were set, the court can review his bond. But I also think
given the way this defendant is exemplified by everything, that it was indeed an abuse of discretion to set his bond at a personal or cognizant bond in this case. Defendant's bond will be reset. The conditions still apply. His bond will be reset at $50,000 cash surety.
Would you consider a 10% provision, Judge?
Cash surety. You can raise it again if you want to on the 12th, but right now he's going.
Fair enough. I hope you and your staff have a great day.
You do the same, sir.
Thank you, Your Honor.
Thank you.
Sir, that's it for the day.
Court calls case People versus Stacy Troon. Just 981. Hello,
Hello, Your Honor.
what's your name?
Stacy Truin.
All right. Mr. Troon, you're here on a show cause. You owe $981. How were you thinking about getting that paid?
I was let off probation and like 2.5, 3 years ago. And my probation officer told me that if I couldn't pay it because I had a slip and fall and I'm no longer working, that it would go to a collection agency. And then I get this letter saying that I got to show cause.
Right. It would go to our collections department is probably what you heard.
Okay.
And then when there's no payment in that regard, then they set it for a show cause before me.
Yeah, I just recently started receiving SSI, but I'm so far behind on all my bills. I can afford like $20 a month.
Pardon?
I can afford like $20 a month.
Why don't we do this? I'll let that happen. So we'll do $20 per month.
20 per month?
Yeah, we'll begin it in July.
Okay.
Okay. All right.
Okay, thank you.
You're welcome. Take care of yourself.
You too.
Court does call the case People versus Angelise Warren.
Assistant Public Defender Natalie Payne on behalf of Angelise Warren, may be present via Zoom. If you're there, please unmute and state your name for the record.
Are both on?
They're both on. She's on here. Your Honor, unfortunately, all the numbers I had and then was able to locate Ms. Warren were bad. I did send her an email. I did not hear back, unfortunately. To that end, I have no explanation.
Bench warrant will issue for defendant's failure to appear in both of these matters. Bond is set in the amount of $7,500. Given 10% privilege, that warrant will issue, those warrants will issue immediately. Court does recall the case of the People versus William Lynn.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Lanham. Please state your name again for the record.
William Alexander Lanham.
You know what's funny? You've been here all morning, and I just keep understanding things about his parents because I know they raised him right. And you know how I know he raised him right? It's when what's her name was coming through the gate, he got up off his seat to make sure the gate was. I mean, it sounds like a little thing, and it's a little thing to you, but you'd be surprised how that doesn't happen. And that
right there.
That just goes to people being raised right. I don't know. I just sometimes get amazed. Go ahead. All right. Where are we?
Your Honor, we did have a bench conference regarding this matter. And the court indicated we will be ordering 4 days. We did communicate regarding a date. I did speak to probation regarding the date, and it seems like she doesn't have a problem with it. It would be July 10th, which is a Thursday. I'd ask if he could report like at 6 p.m.
July 10th. Okay, gotcha.
And then, yeah, around 6 after the workday, and then do serve his 4 days and be out on the weekend. Actually, Your Honor, one more request. He's asking for a little bit later in the day, if that's allowed. He suggested like 8 or 9, 10.
What's the latest they'd like to report there? Just change it. Yeah, I think that's probably late. The
7's the latest.
Yeah.
Yeah, I know sometimes it can take a while to get booked in and you want to get booked before midnight.
I'm gonna order July 10th, 2025 at 7 p.m. to service 4 days. All right, we'll just have to do it that way.
If anything major comes up, is it okay to change the date? With talking.
I'm gonna say no. I'm gonna say if there's something major that comes up, contact your attorney and then we'll figure it out maybe.
Yes, Your Honor.
But right now it'll be set for July 10th at 7 p.m.
Yes.
All right?
Thank you.
Okay, thank you. Mom and Dad, thank you so much for coming down and supporting him.
All right.
Thank you.
Yes, thank you.
All right, you guys take care of yourselves.
Okay, yeah. Thank you again.
Thank you. Fort, is that it for us for today?
That is right.
14A, stands adjourned.
Thank you.
Court calls case People versus Dwight Miller.
Ashley Lonnie for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Miller, who approaches your. Mr. Miller, can you please state your name for the record?
Dwight Miller.
Thank you.
And Your Honor, my belief is that my client does want to set this for preliminary examination. However, I am uncertain. He and I have had some conversations, and frankly, I believe he wants to make some statements to the court. I advise him against it, but at this point, I think he wants to talk.
So we're understanding this is a criminal matter, right?
It is.
Okay, so basically, man, it stemmed from a falsality. All this whole thing, I was falsely arrested, something I never did. I got a sworn affidavit.
Sir, I'm sure your counsel has advised you. I'm going to advise you to not say anything else about the subject matter of the case.
Okay.
If you'd like it set for preliminary examination.
I want to challenge jurisdiction.
You want to challenge jurisdiction?
Yes.
Of whom?
Y'all have a jurisdiction of a case that doesn't exist against me.
On what grounds?
What crime did I commit?
Pardon?
What crime did I commit?
Allege that you committed the crime.
I didn't commit that crime.
Resisting. If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. You're accused of the crime of attempted resist, or not attempted, but resisting and obstructing a police officer.
So we all aware that this never transpired, right?
I am not aware of that.
Okay.
Is that all you have to say?
Mm-hmm. Yes, sir.
So, Your Honor, I would ask Mr. Miller. Mr. Miller, I'm not submitting frivolous motions.
Can I get my affidavit put in on the record, please?
What affidavit?
My affidavit of the incident that transpired.
Your affidavit of what?
The facts in the case. My statement of what happened. Can I get it on the record?
There will be an opportunity if you so choose, if this goes to a further proceeding, for you to put whatever evidence you want into the court. But this is not the time to do that.
Really? So when is the time to put the evidence in there?
If you want it set for a preliminary examination, you'll have that opportunity. And if it proceeds to trial, you'll also have that opportunity.
So once again, I'll ask, do you want to set this for preliminary examination, Mr. Miller?
Sure.
Thank you.
Not really.
See, do you want to set it for prelim or do you want an adjournment?
Preliminary examination.
Thank you.
To your knowledge, all discoveries.
To my knowledge, yes, Your Honor.
People have their witnesses available the 24th.
Yes.
We could try for that date, Your Honor, if possible. I might ask to go one. No, let's do that date. Thank you.
All right. Preliminary examination in person.
will be set June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you.
You want to get this camera? They will have that. I will make that.
All right, the court, I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Yeah, I'll wait for Steve. Arlene Day is the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of in the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have,
excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling, okay.
Yes. The next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So do you understand? You gonna have any questions about the court's ruling? All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to being a third party brought in here without abstract subject matter jurisdiction, and the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case, or, okay.
Yes.
That is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mm-hmm. All right, so the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial, And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized colorable no fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff, and they're the ones that are pursuing and to prosecute me, which is they're one of third party,
Okay.
and I'm not. I don't. Third party, I'm not sure how that works. I know how civil suits, and I know it's criminal law, but I know that. I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand? All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points? Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different.
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay? So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together, because that's the way it was received.
Yes.
There is the next one, which is exhausting administrative relief. My client is not wanting to have that heard right. It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now.
All right, and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand? And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice. And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies, fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you. All right, the next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says, objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible. being admitted wrongfully, and that still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding this collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell, there are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases? No. All right. Does that address that issue for you?
Yes, ma'am.
All right, then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right, does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay.
The other one is the gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, ma'am.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that worries that we have not talked about and the judge has already ruled? Anything other than
No.
All right, is there anything that you don't understand about the jury trial process? All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, sir.
All right, so if you still want a jury trial, Norma, is he already scheduled for jury trial?
Scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome.
We're here today for a sentencing in this case for a plea conviction for use of a controlled substance. The court has received and gone over the pre-sentence investigation report, and I do not see that I made any corrections or amendments. How about you, Mr. Denon? Any objections, corrections to make? I have none, Your Honor. How about you, Mr. Champion?
Your Honor, we have no additional questions in relation to the report.
Allocution, Mr. Champion.
Your Honor, I think the court is very familiar with Mr. Thompson. I know him for quite some time and have assisted him in his most recent child support case and in this case. David's had a struggle most of his life with various injuries and PTSD. He is not dealing with it very well. And he is an individual that we dealt with just a few months ago because of that treatment and his acknowledgement of his need for mental health treatment. I believe the pre-sentence recommendation and plan is well suited for David. He is continuing his path to recovering from past trauma. So I would ask the court to follow that.
Mr. Denon, anything further?
Very briefly, Your Honor, the incident, the defendant was brought to the attention of law enforcement because the EMS was called. It was found bloody. So it just shows the backdrop of him needing substance abuse treatment. That's the focus. That's part of the recommendation. We certainly encourage the defendant to take advantage of it. I would encourage him to accept the help of others. Mr. Thompson is independent in the extreme, and I would encourage him again to accept the help of others. We support the recommendation, and we would request the court follow it.
Right. I don't know if you're independent to an extreme. I'm not really sure. I've seen some that are even more extreme, but that's okay. Extreme to me is the Unabomber, so that's not you. Go ahead, Mr. Thompson. Anything you want to say?
Well, Your Honor, I was an AIT. Obstacle. And I was denied medical 3 times that day.
Which obstacle?
It was a ravine, 16 feet deep, canteen over each kidney, upside down on 16. Boom. Flat on my back. E5 saw it, took me to the drill. So this guy just fell off this obstacle. He's hurt. The drill basically said, I don't give enough. Climb the rope. Because I couldn't even do a push-up. I didn't get medical treatment for 2 months. So I was stuck in this position for 3 days. And I still completed my contract. 2 years. I walked 120 miles in Nijmegen, Holland. I mean, I had an exceptional career. It's been a long road, but it broke my heart. And I walked onto Central Michigan's football team because I wanted to play football. And I had one of them big gorillas pick me up and body slam me on the turf. And I walked away because with this kind of back injury, I could end up in a wheelchair. And today it feels like there's a horse standing on my back. The last 5 tests I've taken with Webster tested they're negative for everything. I'm doing my best. Not seeing my daughters for 3 years and their mother being in contempt of their court orders, the court orders that I have for the name change decree and the seal from public view, it wears on me. I've done my due diligence. And one thing I do want to say, Your Honor, I highly respect you. I respect the court, and I appreciate it.
You panicked me there. I thought you were gonna say something bad.
No. I mean, you know, in my journey through the study of laws and society, I've told law enforcement again and again, you guys have a tough job because the people have lost their minds. They don't get it.
I understand.
And that's the only thing that I have left. I would request that any bonds that the court has post sentencing, I am dating someone, I highly value her. She puts up with me. If there's a bond that can go back to her to recoup some of her, because she's been bonding me out.
Well, I don't do that, but I'll tell you, I'll explain that in a moment. When it's my turn to talk.
I appreciate it.
Thank you. All right, well, the court finds that the sentence I'm going to pronounce is reasonable, proportionate based upon the contents of the investigation report. The court does find reasonable grounds based upon the nature of the offense. And I think a probationary period is appropriate. 12 months of probation. The court adopts the terms or conditions for probation that are contained inside the report. That would be on CFJ 145, pages 2 and 3. It does talk about other intoxicants and possession of substances that could be marijuana, but it doesn't apply if there is a medical marijuana card. The defendant has the right to be considered for probation at halftime if he's been compliant with the terms or conditions. The court sentences the defendant to a 2-day jail term with 2 days of credit. Also, a state minimum fee of $50, a crime victims' right fund fee of $75, a court cost of $100. I'm going to say a fine of $300, which I think is the only difference from the recommendation. A $100 attorney fee, supervision fees of $30 a month, or $60 a month if there's any electronic monitoring. Now, your question about returning a bond, whoever posted it gets to go get the money back.
No, exactly.
So that's still there. I understand. Well, if she's the one that posted it, then she's the one that gets to come back.
Where does she need to go, Your Honor?
The clerk's office. Thank you. The court receives a notice of appellate rights and it's been initialed by. Anything else, Mr. Blazak?
No, thank you, Your Honor.
How about you, Mr. Denham?
Go ahead.
How about you, Mr. Champion?
No, Your Honor, thank you.
All right, Mr. Thompson, good luck. Let's see what we can do to help you. Good luck with your relationship. And I'll note when you kept saying what you have to help you, you pointed to the air. And for the record, I acknowledge that you're pointing to heaven. So therefore, I understand that. Best of luck to you, sir.
It's realizing the delusion of decree of knowledge and good and evil. It hit me about 2 months ago.
Well, that's why we weren't supposed to eat the apple.
That's
Good luck,
exactly
sir.
correct.
All right.
So the next little bit is all Zach's fault. It happened right as we were going live. I didn't know about it. I do know about it now. That's why we have this. Enjoy.
Oh, look like HP is in the waiting room too. So we'll bring him in. All right, good morning, sir. Give me one moment.
Good morning.
Island Park. Oh, is that Officer Monroe? Hello, Highland Park? Okay, we're gonna wait. Your name, sir, for the record.
I'm up your Roman Sister Trust Legal Fiction Corporate Entity Defendant, that's what you want to know. I am one of the
Okay, well, this,
sovereign people.
okay, all right, so this is for Eric Joseph Martin. And officer, can you tell me the person that's standing before you, who they've been identified as far as your records?
Yes, Your Honor. This is Mr. Eric Martin.
Okay,
I object to that, any presumption that I'm a legal fiction corporate entity. I am a living man whose name is spelled capital E lowercase RIC of the capital M lowercase ARTIN family, one of the living people, living on the land. Not the corporate entity defendant.
sir. All right, it's time to listen right now. Thank you and good morning. The court is calling case number 282-257-13-64001. The people in the state of Michigan versus Eric Joseph Martin. Appearances, please.
Jasmine Martin, P 86378, appearing on behalf of Mr. Martin, Your Honor, who indicated that he wishes to represent himself, pro se.
Okay. All right, so Mr. Martin, this is an arraignment. And it's the court, never advises the individual to represent themselves, but you do have that right. You do have an attorney that's here that had an opportunity to speak with you. What's your position as it relates to this arraignment? So you'll need to know how to follow court procedure if you want to represent yourself.
I have a motion I want to make on the matter at the bat. I'll move to dismiss based on lack of probable cause. My sister just told a lie saying I put my hands on her. I told the cops, no, I did not. That is not fact sufficient for the belief, as the US Supreme Court said, and if I remember right, it's Beck versus Ohio or Ohio versus Beck. It's a US Supreme Court case. Define probable cause as fact sufficient for the belief. There is no fact for the belief. There is no probable cause. I was arrested illegally. I want the cops charged also for arresting me illegally, which is assault.
Mr. Martin. Mr. Martin.
It's kidnapping.
No. What we're gonna do, because I want to tell you this, you could challenge the complaint. You'll have a probable cause hearing and you'll have an opportunity to confront your sister at the preliminary examination. If she's not being truthful and the court hears that, then your matter will be dismissed if the court doesn't find probable cause. And if the court does, then the matter will be bound over. But at this juncture, I'm just arraigning you, sir. And that's all I'm gonna entertain today. I'm not entertaining any motions relative to dismissal. The probable cause has been established.
I object.
Arraignment. You can object, and your objections are noted for the record, okay? But I'm just arraigning you. I'm just gonna set a bond, and you'll challenge those matters at the next court hearing, okay?
But I have a right still to challenge it now because see, the officer filled out the complaint form. He's lying by saying he believes I committed. He can't just go off her word and say, "Oh, I believe he committed a assault or whatever or a crime." He's committed perjury just by doing that. I shouldn't even be arrested, let alone still be held here. That's what I'm saying. This is all illegal, violation of my due process rights. So, you shouldn't just be referring to a future date, whatever. Yes, we know that's true, but I'm saying as of right now, though, the issue is still ripe now to decide. It was no probable cause. I shouldn't have been arrested. I should be here now. The charge is dismissed. There is no evidence here.
Talk over me, Mr. Martin.
My sister has been caught lying before on video, which in another case was dismissed in my favor for her same lying self, and she was on video caught lying. This is why the judge dismissed her. So she really has no credibility.
Listen to the court right now. You'll have a chance to take care of those matters later. You'll address all those issues. The court is not trying to be rude. I'm going to arraign you. So I'm going to tell you what you're charged with. It indicates in the complaint that on 6/12/2025 at 9074 Clippard in the city of Taylor, indicates in count 1 that there was an assault or an assault and battery upon Lisa K. Martin. Sir, that is a misdemeanor that carries 93 days and/or you could be fined $500. You also have in count 2 a charge of domestic violence. That is also a 93-day misdemeanor. It indicates that you did make an assault or an assault and battery upon Lisa K. Martin. Again, these are just allegations. They're charges which you have an opportunity to challenge. This is an arraignment. I am going to enter a not guilty plea on your behalf. And officer, do you have any information relative to Mr. Martin's background?
Man, they previously had a lot of domestics with each other. He does not have any ongoing cases at this time, though.
Okay, so Mr. Martin, I understand that you were living at that location, but the court's not going to permit you to return there. You're gonna have to find another place to go while these charges are pending.
That's the house I live in. I don't lose my due process right. It violates my due process right to say I can't live there because she makes up a lying allegation and support. I do not lose that right. That's my right.
You have a pretrial that's scheduled for June the 23rd. You have a pretrial scheduled for June 23rd at 9 o'clock. There is a no contact provision, and you cannot return to the Clifford location. And if you do, sir, that'll be a violation of your bond, and you will end up back before a judge in Taylor to address that.
And
So thank you and have a great day.
Violating your oath of office, you'll be forfeiting your job. That's violating my constitutional right. I do not lose my right to be free just because someone tells a lie with no evidence. That's why I said this case is dismissed now. There is no evidence. There is no probable cause. You do not have the right to tell me I can't go here or go there or be at my only house that I have a right to be at, or leave this state and all the rest of the bull crap orders you judges like to just do traditionally. Like it's okay. It's violating people's human right. It's violating our constitutional due process. You judges are going to stop this with a class action lawsuit. I'm going to make you guys stop this habitage that you're doing. So you might stop it now. Like I said, I'm not. It's not going. You're not going to get away. You're going to get away with violating my due process rights. Telling me I can't be at my house.
I'm done with this matter. Thank you, Mr. Martin.
House to go to anyways.
Okay, I'm done. Thank you so much.
Correct. What is her name?
Okay. Have a good day, Mr. Martin, sir. Take care. All right, we're done. Thank you, officer. Take care.
Thank you.
All right.
Kids, we did it. We made it. Ladies and gentlemen, thank you very much for hanging out with me today. It's been a blast. Turn that down a little bit. Don't know if you can even hear it in the background. That was a scramble. Zach clued me in that it happened shortly after the stream began, and I scrambled. And I do apologize for maybe ignoring a little bit of the chat while I put that together to squeeze into the show. But ladies and gentlemen, it's been a crazy week in court. It's been a fun week. It's been an interesting week. It's been an educational week. But there's many more weeks to come. At least we can hope. We can wait. We can see. But from what we saw today, we've got plenty of court cases to watch for in the weeks to come and in the next week coming forward. So ladies and gentlemen, I do want to thank you for hanging out with me. I am your Lone Wolf Usul. I am your court gallery curator, and I am the host for this here end of week case review. Thank you for hanging out with me. And ladies and gentlemen, I'm going to say I'll see you next time. Thank you very much for coming by. Come by every Saturday at 11 a.m. Central Time, 12 p.m. Eastern Time, and every weeknight right here on this channel. Hang out with us for a live chat. That's 8 p.m. Central Time, 9 p.m. Eastern Time. We have a large group of people who get together, and we have a great chat that just goes on and on and on. Usually we're here for about 2 hours. So come on by. Come on by and hang out with us. We'll see you next time. Thank you very much for coming around. My throat's giving out. My voice is gone. Ladies and gentlemen, I couldn't help it. I had to clear my throat. It's just all there is to it. What more can I say? I'm bad at this streaming stuff, you know? Be safe, everybody. Pepla, thank you for the corrections earlier. Florida Punk, great to see you again. Mama, thank you for the moderation as always. Rhonda, wherever you are, Rhonda, be Rhonda. Buzzy, good to see you. Patrick, good to see you. Good to see everybody who's here every week. Barry, you know, Eileen, I know Tev's out there, Amy's out there, Kier's out there, Buzzy. You know, the music is stopping and I'm still talking. So, ladies and gentlemen, I'm out. Sort of. Not really. This is really me right now. Y'all have a good day. We're done. There's the dogs. Say bye. Bye.